Bill C9 will implement UK-style censorship laws into Canada.
Thank you to all the witnesses for your time and analysis on this. I'd like to start with you, Professor Party, and because you're joining us virtually, you didn't have the privilege of seeing the Liberal members of this committee snickering as you were talking about the Liberal government's assaults on civil liberties in the past. But I think that is important context for what we're seeing here, because in your opinion, these are not benign provisions. These are significant expansions of the power of the state to regulate thoughts and emotions and expressions, correct?
Correct, yes.
So when you look at language, and I'll ask you this as well after Professor Alford, but first, Professor Party, in your analysis of legislation in the past and your knowledge of statutes, when words are omitted from jurisprudence, that is not what codification of jurisprudence is, correct?
Correct, yes.
So explain in practice, if you are a police officer that is doing an investigation or you are a judge weighing in on this, how significant is the omission of the words extreme manifestation from the definition of hate that exists in the common law now to the one that C9 puts in law in the criminal code?
Yes, so thank you for the question. And this is really Professor Alford's point. You have a common law, you have a jurisprudential context. The Supreme Court of Canada in the 2012 case of Whatcott describing what was a reasonable limit on freedom of expression. And let's just underline this. They said that this was a reasonable limit, but they also said that this is an infringement of freedom of speech. So what you have to start with in C9 is an infringement of freedom of speech. This definition does infringe freedom of speech. That's what the Supreme Court says. Okay, so this is an infringement from a government that claims to be a government of the Charter and of rights. So we start there, and then if you fiddle with the wording, if you leave words out, if you make it detestation or vilification and not and, for example, then you are downgrading the threshold above which you need to get in order to find that this is established, right? So it's a little bit of playing around with the words so as to appear as though you're doing exactly what the Supreme Court said, while you're not really doing that at all.
And I'll go to you on this, Professor Alford. I believe you did review the Minister of Justice's testimony on Bill C9, and in that he said, and I'll quote directly from what the minister remarked here. He was asked about the definition. He said, "This was not an attempt to dilute the definition. It was an attempt to make good on the spirit of that definition and provide clarity to law enforcement." What is your view on the minister's characterization of his own bill, Professor Alford?
It's incorrect. And I would say that the problem is that the courts are going to look at the decision to use this particular language that omits the language from Whatcott that I cited in my testimony and say, well, that's clearly an intentional decision. You made the decision, seeing what was written in Whatcott, to leave this out. Now, the most ominous possibility here is what's going on behind the scenes, is that the government is actually seeking a ruling from the Supreme Court in due course that would lower the threshold to what they're putting forward in this bill. They're saying, well, you said that in 2013. If you uphold what we wrote into this bill, which intentionally left out some of the language that Justice Rothstein, since retired from the court, of course, included in that judgment, that you will then say that this is a reasonable limitation on freedom of speech. And I think that's particularly dangerous.
Explain to me, if you could, Professor, and I realize that hate is inherently subjective, which is the problem that we've been identifying with this, but what would the practical application be in your view? What would be captured by this new definition that isn't captured under the existing definition, just to demonstrate how this dilution and this lowering of threshold is actually happening? Or is there no way to make such a prediction right now?
Well, I think there is, Mr. Lawton. I would just say, if you look at what's happening in the United Kingdom right now, where, now remember, there's no entrenched right to freedom of expression in the United Kingdom. They don't have anything like the Charter, which creates that right. So there you have speech that purportedly abrogates the dignity of individuals or groups. That's the basis for complaints to the police. And arrests are being made on that basis. Now, that's what the language from Whatcott that is left out in the proposed definition of 319 sub 7 would allow, precisely that, people to make complaints that what someone's saying is hatred. And the reason why it's hatred is because it's an intentional attempt to infringe their dignity as an individual or members of a protected group. So we've seen quite a lot of this in the United Kingdom, particularly with very charged issues such as competing rights around what's called gender identity issues and women's rights, where you've had many people who felt like they were engaging in good faith, who are now the subject of visits from the police and then arrests because of the complaint that what they've said and the way that they've engaged on this issue is engaging and detrimental to the dignity of the people with whom they engage.
It's a valid point, Professor, and I know that Minister Fraser had mentioned to my colleague, Mr. Baber, that it was, quote, far-fetched to imagine UK-style tweet policing in Canada, and then moments later, he admitted that Bill C-9 will cover what people say on the internet. So very quickly, is that a legitimate concern for Canadians if C-9 passes, Professor?
It's eminently legitimate, Mr. Lawton.
Professor Party, by lowering the threshold for what constitutes hate speech and removal of the requirement for Attorney General consent, do you think it opens the way for potential politically motivated prosecutions?
Yes.
Can you maybe expand on how that might happen?
Well, because you will have a criminal provision that is completely uncertain in its meaning, and the people who are out there on the street will have no conception about where the line is between things that are okay and things that are not. And you don't have a check on political decisions like Professor Alford just alluded to. And so you basically have an open book. You can if you have the political wherewithal, the means to direct certain outcomes, then certain prosecutions, certain initiatives, then of course that's what you will do. And that is a poor way to construct the law. You are asking for trouble instead of trying to design the law so as to prevent the possibility of that kind of outcome.
Professor Party, Bill C-11, Bill C-18, Bill C-63 from the previous Parliament, and now we have C-9. What do you think it is with this Liberal government that's been in power now for over 10 years and their general aversion to free expression and persistent attempts to restrict free speech in Canada?
Well, there does seem to be a determination to make sure that the government is the one supervising people's speech. And I would like to emphasize the distinction that I alluded to earlier, which is that the proper restriction on speech in my books is one that distinguishes between violence and speech that is not violent. So it's perfectly adequate to limit speech by saying you cannot use speech to threaten violence. That makes sense, and we have that in our laws already. We had them for a long time. But all of these legislative initiatives, especially Bill 63, which was, for my money, the worst of the lot, but including C9, is attempting to cross that threshold and say, well, even if violence is not involved, even if you are not threatening violence, you're still not allowed to say certain things because we don't like it. And that's where you get into dangerous territory with freedom of speech. That begins to mean that your guarantee, your constitutional guarantee of free speech is not that at all. You can just compare the Canadian state on this to the situation in the United States. I mean, we both have, in both countries have a constitutional guarantee of free speech. In the United States, the government is not allowed constitutionally to limit speech, which here would be called hate speech. Hate speech is not a thing in the U.S. because the courts have said that is protected speech. And yet we've ended up in a situation here in the legislation that you're alluding to where the government is trying here and there and everywhere to try and limit how people talk.
Professor, what do you foresee as the worst case scenario of this bill should it pass? What is the slippery slope? Could we see people being arrested for edgy social media posts? Could we see political opponents. I have to bring up this hate speech thing. We have liberal members of parliament who have accused Jordan Peterson of hate speech, who have accused the recently assassinated Charlie Kirk of hate speech. Are they not, by making this accusation and then putting forward a bill like C9, essentially calling for their political opponents to be jailed?
Yes, well, potentially. Anyway, I mean, you wouldn't want to make that accusation without some concrete information, but essentially, yes, you could see happening in Canada the kind of thing that has been happening in the UK, where the police are sent out on missions to crack down on people saying, dangerous things online. I mean, that is not the situation you want in a country that claims to be free. You do not want a political role in determining what people can say. And the Jordan Peterson case is an excellent example.
Professor Alford, I have 30 seconds with you. You talked about the potential for this bill to violate the charter and be struck down. I did a documentary on free speech a couple years ago. There was a 5-4 decision that almost basically fined a comedian for telling a joke. How confident are you in the current makeup of Canada's Supreme Court to uphold free expression rights in Canada?
So the Ward decision that you alluded to would have completely changed the framework for the evaluation of reasonable limitations on freedom of speech. It was extremely troubling to see that it was considered a close question by a number of the justices. So I would really have strong fears that were this to come to the Supreme Court of Canada, that they would reevaluate that framework with the idea of balancing freedom of speech against some other compelling objective, that it would really be fundamentally dangerous to the democratic accountability and legitimacy of the government, and indeed our constitutional state.
There's no better way to put it. A country that's supposed to be free, but the government is trying to limit its people at every step. If Bill C9 passes, they better build more jails and hire more police officers, because I can only imagine a lot of people going to prison over stupid things. And also considering the fact that everybody's offended over everything now. And if you've made it to this point in the video, I would just like to point out that all live streams going forward will be happening on the Windy Talks archive. So if you are interested, check out that channel as well. Anyway, I would like to know what you think down in the comment section below, and have a good one.